Today is about telling your story to a judge. So, how can someone effectively tell their story? One of the hardest things is, what does a judge actually want to hear?
What often happens is people go right to the emotional stuff. He did this, she did that, da, 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 da. And there's really no tie to the law. There's no chronological storyline.
Right,
There's just this emotional dump.
right,
And the judge hears this stuff day in and day out. And it's just like in one ear, out the other. And they're like, okay, well, why is this best for your kid? You know, the judge is trying to get it into the law stuff. And they're like, oh, but he's a horrible parent. But, just using these generalities and this name calling, that does nothing to help the judge, because you need to tell a story about what happened. It's the facts that are really the most persuasive part of a case. And the challenge is that there's a million ways to tell a story.
right.
And so what do you highlight and what do you leave out? And that's, as lawyers, what we are so good at. I want that fact in, and I'm going to highlight this, and I'm going to really try to ignore this thing.
Minimize that.
And so, that does take some inside knowledge, but that's the goal, is to find a way to tell the story that really highlights the things that matter.
Right. Yeah. And it's hard to know what are exactly the things that matter, but there are some things that everybody can do to become more effective at telling their story. And Julie touched on the fact that you need a lot more background generally, but the background that they need is the facts, what happened and when, the highlight, the timeline, if you were in a history project in 5th grade and you built a timeline, it's almost thinking about it like that. Like, what are the critical events that happened that led to this particular hearing? Now, one of the things that you were going to talk about is knowing what is the hearing I'm going in for, or what is the motion that I'm arguing, so that I know how to tell my story.
Some people think that, especially self-represented parties, they think at every hearing, it's like time to give a closing argument. But it's not. There's a time and place for a closing argument. And so understanding the procedure and what's going to happen at each hearing is really important, because if you don't understand that, you could come away feeling like you got gypped, like the judge isn't hearing you and you're getting the short end of the stick and you're not being treated fairly, when really it's like, no, this was a resolution management conference. Like, I don't want to hear any facts. I'm just here to see where you guys are at. And are you going to go to mediation, or do we need to set a trial date? Like, the judge doesn't want to hear anything about accusations at what they call an RMC, a resolution management conference. And so if you're going in and being like, oh, but he or she, da, 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 and the judge's like, you may think that the judge doesn't like you, or that, the system's against you, but it's just, no, you haven't brought your issue to the judge in the proper way to get that thing heard. So you're going to need to understand what type of hearing you're going into and prepare accordingly. That is probably one of the biggest challenges for self-represented parties, because even if you're like, oh, well, it's an RMC, well, okay, what does that even mean? You need more information than just the name of the hearing to understand what happens at that type of hearing, and then understand like what is expected of you.
The RMC is a great example because it is set in every case, and it's supposed to be non-evidentiary and non-argumentative, but people can be left very frustrated when one party spends that time arguing and testifying, and a judge allows them to and doesn't cut it off. And it's the case's first impression in front of a judge. And someone can be left feeling very, very frustrated if they didn't get to say their response to those accusations. What do you think about that?
It's interesting. I have not seen that at an RMC. Don't know why, but I have not seen that. So yeah, that would be tough. That would be really tough. And, sometimes it just feels like it doesn't go right. But you also have to remember that the judge may or may not actually remember those arguments that were made
Right.
that day. Like, is it really going to change the outcome of your case? Possibly. Or it could just be another day and the judge heard 50 other things. And between now and the time he sees your case again, he's heard 1,000 other things and this meant nothing and he doesn't even remember. Don't know. But, that's just where, if you understand the context of the hearing, you may be ready to make a really powerful objection and say, Judge,
Right.
objection, this is a RMC.
Right.
Let's talk about scheduling. Stop slandering me.
Right. I love that. I love that because you have the ability to stand up for yourself, to make your point, to say, Your Honor, I know that you don't want to hear my rebuttal to all of those things, which I do not agree with, because we're here for an RMC. And this is what I'm asking you to do today at the RMC. Like, that is powerful.
Mm-hmm. And I can see a judge being like, you're right, let's move on.
Right.
Okay, what are we doing next?
Mm-hmm.
And this is the thing that so many people don't know, is the judges are rooting for the self-represented parties. They want them to do well. Like, they want a smooth experience with these self-represented parties. And I've seen judges help self-represented parties to no end. And so if you can come in and you're prepared and the judge is like, wow, I mean, the judge may want to help you even more. So getting this information and being part of Win Without Law School could be really valuable. Okay, so understand the type of hearing you have, prepare for that. And then let's say it's the type of hearing where you do get an opportunity to tell your story. It's some sort of evidentiary hearing. Okay, it could be on a motion for temporary orders. It could be a final trial. It could be an oral argument on a contested issue. Always remember that the judge has hundreds of cases. You need to know that this time you have with the judge is really important. And when you talk, you need to make it so that it's something that the judge is going to remember. I'm not saying it needs to be catchy. I'm not saying it needs to be like something totally polished, but it needs to be something that the judge is going to be like, oh yeah, they have a daughter named Sarah, and Sarah is 7 and she has special needs. And because of those special needs, I really need to pay attention to a few things in this case because Sarah has special, like, you need to make things really clear for the judge about why your argument is important.
Right. What is different about my story? What is unique about my story? How do I not become lost in the sea of all of the other divorces? And then, I mean, unless you have an uncontested divorce, and then maybe that doesn't matter and you can be lost in the sea. But like, if you really have a contested issue where you need a judge to make a decision, then you need to not be lost in the sea. And you have to give enough background. Many times it's easy for us to jump into our argument, assuming that the judge feels the same way about the past and about what the facts are as you do. So you might lay out the facts and then have a conclusion in your head and expect them to jump to that same conclusion. So going back to what we were talking about, you're making the timeline, right? You're dropping the facts, but then you also have to spell out, and these facts mean X for my case because my case is special and here's why.
Right. And I also like to create a visual for the judge. So let's talk about custody, because I'm sure that's, what is one of the most common case types of our audience. Pictures of the child's room, just showing what life is like for the child with me. Like, this is the life I can provide this child. And it seems very simple, but again, the judge has hundreds of cases, and now the judge has an opportunity to see a picture of what, Sarah is one of our co-hosts here, but I use the name Sarah for the child, what Sarah's life is like with mom or dad, and then it could go further into other stuff too. But, individualizing your case can be important. And it could, and just having that as a guide as you're creating your case, I think can be very helpful.
Yeah, I totally agree with you. And it's hard to know how much, right? You don't have time to flip through your entire photo album, your entire baby album. You won't have time for that. But you do have time when you're talking about the best interest factors, when they're asking you, what can you describe your relationship with your child? If you say, we worked on this project together and I'm so proud of him. Like, look at what this child did. And he got 100% and we did it together. And that was great. That was one of the things we like to do. We also go to the movies. We do this, we do this. Like now, when the judge has to make findings, he has to think of something to say, or she, in the ruling. They don't have an option. They have to put something in, and you've given them something to put in, as opposed to just Mom said it was good.
Yeah. And that's such a key point, is starting with, this conclusion of what you want to show, and then identifying those facts that illuminate that point, and then testifying to those or eliciting those on direct examination, or having an exhibit that, illustrates the point you're making. It's just, if you're just going to get up there and go on and on and on, oh, and then the dog barked, and then I opened the door, like, the judge is human. The judge is going to tune out. Like, we're all human. And so engage, tell an engaging story. And it's not that you have to be some expert storyteller. It's about crafting your story around compelling facts.
Yes. So what, and this is hard. So what I think you need to do when you're thinking about telling your story, first figure out what type of hearing am I going into? And then ask yourself, what decisions is the judge going to be making? What is on the table? What decisions is the judge going to be making? Then ask yourself, what do I want the judge to decide?
Yeah.
Then after so let's take the custody example. I want the judge to order my child stay with me during the week and have weekends only with dad. If that is what you want, now you know what you have to prove, and now you know the story you have to tell. And then you're going back and you're finding the applicable statutes, and you're determining what evidence in my story meets the elements of this statute. So it's a very systematic way to figure out how to tell your story.
Yes. And this, like, Billy, what you just explained is the step-by-step process that we take as lawyers when we prepare for hearings.
Right.
Right. Okay. What type of hearing is this? Okay. All right. What do I want the judge to do? Okay. How am I going to get him there? Him or her?
Right.
And that's what you've just laid out. And that's what Win Without Law School is going to teach in a more in-depth manner. Showing, okay, here's the statute, like taking you to those places in the law to help simplify it. But that is so true. And a big question to always come back to is why, from the judge's perspective, why should the judge rule for me on this issue and on that issue, on the parenting time? Why is this best for our child that my proposed parenting plan go into place? Why should we have joint legal decision making? All of those things, that could be a really good starting point if you're like, I don't even know where to go with this. Oh my gosh, there's so much that's happened.
Right.
Okay, let's break this down. Why? Okay, what do I want? What am I asking the judge to do? And then why is this best for our child or children? And then how do I, what events illustrate that? So if, for example, let's stick with what Billy said, with mom during the week, with dad on the weekends, and your mom, talk about the structure. I would even create a one-page exhibit that had a general week of what it looks like at my house. It would just, on Excel spreadsheet, I'd have the times, the days, kids are in school, this is what we do, then we do homework, boom. Now the judge has one document that could take a half hour to explain, but now it's boom, it's there. Yeah, this is what we do every week, and this is when we spend time, and we exercise here, and we eat well here, and they go to bed by here, and their homework's done, and look, oh, and then exhibit 2, here's their report cards. And here's when they were spending more time with dad and what their report card looked like. And now that we've got this really nice schedule in place, this is what, that's going to prove why the kids being with you during the week is best for them. So now you're not just like, well, dad doesn't get them to bed on time and and it's not just all these accusations about dad. It's now changing it to the kids and why this is working so well for the kids. And of course, you can throw those jabs in at dad along the way, but your whole presentation isn't just now dad sucks. It's like
Right. Or
deeper than that and more detailed.
right. The more you can humanize your kids, if you're arguing for that you keep your children during the week, you need to know what an uphill battle you have, because culturally and philosophically, judges want both parents involved in all aspects of parenting, which, that's not exactly how intact married couples function. It is not unusual for intact married couples to delineate roles, but the culture has judges really moving in a direction where they want both parents to have the opportunity to do all of those things. But if you can talk about how dad having the child on the weekends is the best for the child, because here are the things dad does with the child on the weekends that the child really loves, and here's the things that mom does with the child during the week that the child really loves, and how this really serves the child's best interest and maximizes the strength of each parent. Ooh, like that's a compelling argument.
Exactly. All right. I think we've covered that point pretty well.
Yeah.
The next point is related, but it's a little bit different. And it's to, when you go into this contested hearing where you have the opportunity to tell your story, pretend that the judge, like you're meeting the judge for the first time and the judge knows nothing about your case, because you're going to tell your story in a more detailed way. If that's the approach, because you're not going to be like, oh yeah, and then they went there and she said that and I did this and he made that, and the judge is like, well, who's he, them, there, where? You really need to be specific with names and explaining. You can't just start talking about Mimi and not explain that Mimi is the paternal grandmother or Mimi's my mom. You need to lay out who Mimi is. Otherwise, the judge is not going to really be listening to you and instead be thinking, who's Mimi? Who's Mimi? And not really be hearing the rest of the story.
Right.
So you need to lay that background about who each person is and have that support the whole story. Otherwise, there's going to be a lot of holes in the story and the judge is going to be confused.
I think it's important to note that people underestimate the amount of time it takes to write a good story. When I am representing a client and I'm writing a pretrial statement or a motion, and I'm doing my best work, I'm going back and rewriting that 3 times.
At least.
And does that take a lot of time? It does. But if somebody's relocation's on the line, then me making a chart that compares life in X place versus life in Y place and all of the characters and all of the locations, and then cutting out anything that doesn't serve the argument. It takes a lot of time and effort, and it is worth it.
And this is the thing, your case the best. Like for us, we're constructing somebody else's life and, trying to piece out the details and call it, oh, but then what happened then? And, we're like doing all that stuff. Like if you're representing yourself, you already know all of this stuff. So that is very helpful.
And one of the best things you could do, if you're on our Facebook page, that there are 1 million people in here going through the same thing you are. Not 1 million, but 850. Find somebody that you're not friends with. Ask them to read your story. They don't know you. They haven't heard about it day by day, detail by detail. Let them read your story and ask them, what did you think after you read my story? Did you feel like there were any holes? Because the judge is that person. He or she is a stranger. They don't know you. They don't know your kids. They don't know your case.
That's such a good point too, because if you're really angry you could write a story that's just so biased
Yes.
and so uncompelling because it's just you, dumping all of your emotions.
Yes.
The pretrial statement is not your journal.
No.
And so having somebody else read it could be really helpful to, address tone, address, angling arguments so it's less throwing mud at the other side and more artfully throwing the mud so that it's more positioned to support the law and what's, on the table. So I think that's a great idea of having a neutral, total outsider read it to see if they're like, oh, you come off pretty bitter here, or if they're like, oh no, I was crying, you got to win this case. Your kids have to be with you. I'm sold. What is the response?
Right. Same thing when you're asking your questions of your witness, like letting somebody who has not heard your case before hear that will help you determine, did I leave gaps? Because it's easy to leave gaps when you're telling your story to the judge.
Oh, definitely. Yeah, you don't even realize it. And then
Right?
somebody else is like, but wait, how did you get from 2015 to 2020? Like what happened in those 5 years? I'm confused.
Right.
And you're like, oh, nothing. That's why I left it out. Nothing happened. It's like, well, still, at least say something about it because it's confusing. It sounds like you're trying to hide something.
Right. Right. So we do want to leave time for Q&A. Do we have any other points on telling our story?
There's one final point, which is if you can, look to identify 3 to 5 major points you want to make and craft your story around that. And then once you've got your story figured out, tell your story over and over again. That's kind of how it goes, is you want to be consistent. If your story keeps changing, I know new things happen, but if you're changing a past story that you created, that's going to create, red flags in the judge's mind. So you got to stay consistent.
That's a great point. If you go back and watch our past Facebook Lives, we've talked about creating a theme and theory for the case. We've talked about how you're telling a story, and these stories involve characters, and how you need to be in character and tell that story consistently at the same time. So definitely go back and watch those. If that's something that you're having a hard time figuring out, well, how do I come down to 3 to 5 points? If you've got your theme and you've got your theory and you know what you want, then you can really come up with the 3 to 5 points. The other thing I would again tell you that is helpful is sometimes letting an outsider read something and then having them tell you, this was what was most critical for me. That can be very helpful, because something that you might not think is a big deal could be like a real thing to focus on. And thank you all for being here. Thank you, Julie. Thank you, Sarah and Brianna.